Thank you all for coming and joining us virtually for this presentation for the Gwinnett County Public Schools Transition Fair. My name is Kim Martin, and I am an attorney and a partner at Harrison and Held. And my entire practice is focused on working with families that have children with special needs. Before we get started on this presentation, I have to give you my disclaimer, which is that this workshop is for educational purposes only. So in other words, nothing that I say today is legal advice. This is just purely intended to be informative. Any opinions that I express in this presentation are purely my own, and I'm not speaking on behalf of any other entity. And finally, and most important, this video is not intended to be a substitute for a sit down with an attorney who knows what's happening in your personal situation and can give you specific advice that pertains to you. And I'm not going to read you my credentials. I know everybody can read, but I will tell you how I got here. When I was in law school, I had a professor who told us lawyers are paid worriers. And I knew that I was in the right place because I am really good at worrying, and I always have been. For the first 6 years or so of my career, I was a tax lawyer, and my job was to worry about money, not my money, other people's money. And then I had my son, Finn, who was diagnosed with autism when he was 2. And that is when I became a truly world-class worrier. When Finn was little, I had a recurring dream that he was running off a cliff or he was in the path of a speeding car. And the disaster changed from one night to another. But every time I had this dream, there was one thing that was the same. I couldn't move. And I had no voice. I couldn't protect him from the danger that I could see coming. I finally stopped having that dream when I reinvented myself as a lawyer. And now I spend all day working with families like mine that have a child who will need lifetime support. And something that I've learned from my practice is the more you plan, the less there is to worry about. So that's what we're going to talk about today. Planning. You're probably here because you've heard something about special needs trusts, and that's what we're going to spend most of our time on. But first, we have to talk about when a special needs trust is appropriate. So there are 2 questions that you should ask when you're deciding whether you should be doing special needs planning as part of your estate plan. And the first one is your child disabled for purposes of public benefits? So that term disabled has a legal definition. And if your child is under age 18, that definition is that they have a medically determinable physical or mental impairment that results in marked and severe functional limitations. What that means really is, does your child have a diagnosed condition that is serious enough so that they're not able to function in the same way that a typical child can? Once your child turns 18, then the definition changes, and it's really more of a dollar-based definition. So when your child turns 18, they will be considered to be disabled for public benefits purposes if they have some type of diagnosis that prevents them from engaging in what's called substantial gainful activity, or SGA. So in order for them to be unable to engage in SGA and to be considered disabled as a result of that, they have to have some type of condition that's considered basically permanent, or that will last for at least 12 months. And their condition must be so severe that they can't do any type of work that exists in the national economy. So that doesn't mean they can't engage in substantial gainful activity if they don't have a college degree and they're never going to work as a CPA or a doctor or a lawyer. It means there is not a single job out there that they can perform that will pay them more than the substantial gainful activity number. And that number changes every year. For 2023, it's $1,470 a month, unless you are legally blind, and then your number is $2,460 a month. So even if your child has some kind of a part-time job and they make $15 an hour, as long as they are unable to earn consistently this SGA number, then they would be considered disabled for public benefits purposes. So the second question that we need to ask is, does your child receive or expect to receive means-tested benefits? So the means test is a $2,000 resource test. If your child has less than $2,000 in non-exempt resources, that means they passed the means test and they should qualify for these means-tested benefits. The two big important ones that most people have heard of are SSI and Medicaid, and we're going to talk a bit more about both of those. But SNAP, which used to be called food stamps, is also a means-tested benefit. Section 8 housing is a means-tested benefit. In Georgia, that's kind of a moot point because there's not really a great enough supply of Section 8 housing for most people who qualify for it to actually be able to find it. But it is means tested. And then there's also a trust fund that the state of Georgia has set up. It's the Brain and Spinal Injury Trust Fund. So if you have a traumatic brain injury or a spinal cord injury, you can qualify to receive funds from that trust fund if you pass the means test. So SSI is the first big benefit that people typically apply for when they turn 18. It is, as I said, means tested. So if your child has more than $2,000 in non-exempt resources, they automatically will be disqualified from getting SSI. Assuming that your child does receive SSI, that amount that they get every month is going to change every year because it adjusts for inflation. So it's always some kind of strange random number. For 2023, the maximum that you can get in SSI is $914 a month. The reason that most of our kids don't get SSI until they turn 18 is that before that age, Social Security attributes the resources that the family has to the child. And that's because until they turn 18, we have to take care of our kids. We have to give them a place to live. We have to feed them. We have to make sure that they're safe and that they have everything that they need. Once they turn 18, Social Security is going to consider them to be a household of one. And what that means is they stop paying attention to what the family has and they only pay attention to the child's personal resources and assets. So in addition to the means test, there's another test that applies, and that's the income test. Social Security will disregard the first $20 of income that your child has every month, and then all the rest of it will offset that SSI amount dollar for dollar. So if your child has too many resources or too much income, that can reduce or eliminate SSI. And the last important thing to know about SSI is that it's statutorily linked to Medicaid. So once you get SSI, you get Medicaid in Georgia. So Medicaid is medical insurance. It's also means tested. The same $2,000 test applies. And again, family resources count until the child reaches age 18. But unlike SSI, there's an exception to that rule. And that is, it's possible to qualify for a Medicaid waiver that's called the Katie Beckett deeming waiver. If your child is sufficiently disabled to qualify for the Katie Beckett waiver, then they can get Medicaid before they turn 18. Medicaid is in some ways an even more important benefit to have than SSI. And that's because there are so many different kinds of Medicaid, and there are types of Medicaid that will provide various types of support for your child throughout his lifetime. So of course, there's Katie Beckett until they turn 18. The now comp waivers are both waivers that provide funding for people, paid caregivers to give care to your child. Typically, people get that as adults. Family support is not Medicaid per se, but it's funded with Medicaid dollars. And it's a fund that you get every year that will pay for things like swimming lessons, boxing classes, summer camp, membership at a gym, that kind of thing. And it's something that you can get if you have a diagnosis of intellectual disability and you don't yet have a now waiver or a comp waiver. So once you get one of those big high dollar Medicaid waivers, family support will go away. And then later in life, there's a type of Medicaid called nursing home Medicaid. And that is when Medicaid will pay for some or all of the cost of your care if you need a nursing home level of care. An important thing to remember about Medicaid is that when you receive Medicaid, that means that your estate is going to be subject to estate recovery. It's a Medicaid payback. So anything that your child has in their estate at death, Medicaid will seek payback, not only from their estate, but from a first party special needs trust or an ABLE account, if they have those things. So what does all this have to do with special needs planning? The short answer is special needs planning is really a combination of estate planning and benefits planning. So if we have a child who is not on benefits and never anticipates being on benefits, we don't really necessarily need to do special needs planning. But the goal behind creating a special needs trust is that trust serves as a receptacle to hold assets in a manner that causes them to be an exempt resource. So it allows your child to qualify for means-tested benefits and still have other resources to supplement that care. There are two main types of special needs trusts, the first party and the third party special needs trust. The first party trust is sometimes called a self-settled trust, or you might also hear it called a D4A trust. And its job is to hold first party money, meaning money that belongs to your child. We don't want to put our own money into a first party special needs trust because it is subject to Medicaid payback, as I mentioned. So at your child's death, any assets that remain in a first party special needs trust will be subject to estate recovery, and Medicaid will take those assets to reimburse them for the care that they've provided during the child's life. The third party special needs trust is really the classic estate planning trust. Sometimes you'll hear it called a supplemental needs trust because it's intended to supplement and not supplant any benefits that your child is entitled to get. So the third party trust obviously holds third party funds, and that means funds that belong to anybody in the world except your child. So this trust can hold your money, it can hold grandma and grandpa's money, it can hold any type of asset that you have that you want to put into it, as long as it doesn't belong to the child. The reason that the third party trust is the classic estate planning tool is that there is no Medicaid payback at the end of the child's life, which means if you put the majority of your resources into a third-party trust for your child as part of your estate plan, and you have other children that might get a smaller share because your special needs child is the one that really needs the funds, then at the end of your child's life, the remaining assets will go wherever you say they go. So you could direct your assets at that point to the other kids. First party trusts are creatures of statute. That's why they're called D4A trusts, because that's the last little bit of the code section that allows them to exist. And I always think of first-party trusts as sort of the damage control trusts. These are the trusts that we would want to use if we have some kind of crazy disaster happen, money has fallen out of the sky and it's landed in your child's lap, and all of a sudden we're worried about having them disqualified from benefits. And if that happens, the first-party trust is a perfect tool to use. It's a place to park those funds. Only certain people are allowed to create a first-party trust. So a first-party trust can be created by a parent, a grandparent, a guardian, or a court, or it can be created by the beneficiary, assuming that they have capacity to create a trust. First-party trusts are subject to the sole benefit rule, which means that every asset in that trust must be used for the sole benefit of the beneficiary and not for anybody else's benefit. A first-party trust has to be irrevocable from the day that you sign it, meaning you can't take the money back out once you've put money in there. You can't revoke the trust and just make it go away. And it has to be inter vivos, which means during life. So it has to be created during life as opposed to being created under a will. It can't be created or funded for a beneficiary who is over age 65. There are ways that we can use the first-party trust as a planning tool if we have the right circumstances. So if we have, say, an older family member, maybe a grandparent, who has been diagnosed with something that we definitely know is going to require a nursing home level of care, and we want that older family member to qualify for nursing home Medicaid, if we use their assets to fund a first-party trust for the benefit of another person who needs it, like, say, a grandchild who's disabled, then the grandparent can immediately qualify for nursing home Medicaid instead of having to wait until they spend down all their assets. But do keep in mind, people don't like this trust sometimes because there is an estate recovery at death. So why would we use a first-party special needs trust? We might need to use it for intestate distributions. In other words, if our child is the intestate heir of somebody who dies without a will, then we can park that money in a first-party special needs trust and keep them qualified for benefits. If your child is the beneficiary of a trust that's not a special needs trust, so a well-meaning grandparent, let's say, has left money in a trust to take care of your child, but it's not a special needs trust because it doesn't have the magic language that makes it a special needs trust, all of that money in that trust is considered a non-exempt resource. The way that we would fix that is to put that money into a first-party trust. Tort settlements, if your child is in a car accident, let's say, and they're entitled to damages, those damages are a non-exempt resource. So typically in that situation, if the personal injury lawyer knows what they're doing, they will ask the court to order that that settlement money be deposited into a first-party special needs trust. Any surprise income that falls out of the sky, if your child gets one of those PPP checks and it puts them over $2,000, you can put it into a first-party trust. A lot of people don't know that child support is considered to be income to the child by Social Security. So that can either reduce or sometimes eliminate SSI. The way to fix that is the divorce settlement agreement should require child support payments to be made to a first-party special needs trust. And another use that people have for this trust is if you're in the military and you have a military pension, you can name a first-party special needs trust for your child to be the recipient of the remainder interest in your pension, so that we're not disqualifying the child later in life from benefits. Third-party trusts are the classic estate planning trust, as I mentioned, and they are not creatures of statute. There is no code anywhere. There's no black letter law that tells us what we have to do to create a qualified third-party trust. So over the generations of special needs planning that attorneys have participated in, we have all just kind of given stuff our best shot, and when it works and the trust qualifies and Social Security and Medicaid don't have a problem with it, everybody kind of tells everybody else, hey, I have this provision in my trust and it seems like it works. So third-party trusts have kind of grown and developed through practitioners who have just kind of taken their best shot and put in the provisions that they think should be there. So because we don't have a statute that tells us how to create these trusts, they're a lot more flexible. Anybody can create a third-party special needs trust except for the beneficiary. There is no sole benefit rule. So if we have maybe more than one special needs child, we don't have to create a special needs trust separately for each of those kids. We could create a joint third-party special needs trust if we need to. The third-party trust can be revocable or irrevocable. So typically when I draft a third-party trust, unless I have a good reason not to, I make it revocable. And that's because it gives us the flexibility to modify the terms of that trust by doing an amendment, or even to revoke it altogether if we have a good reason to do that. It can be testamentary or inter vivos. So a testamentary third-party special needs trust would be a trust that you create under your will. That's not my favorite way to do this, because if you have a testamentary trust, it doesn't exist until you're gone and your will is in effect. If you create instead an inter vivos trust, and remember that means a trust that is created during life, so it exists the day that you sign it, then not only can you use that trust to put assets away for your child, but other people in the family can use it. So if you have grandparents or aunts and uncles or some other third party that wants to give money to take care of your child, the best way to create your third party trust would be to make it be an inter vivos trust, so that grandma and grandpa can use it for their estate planning, or maybe they even want to make gifts to it during their lifetimes. And finally, unlike the first party trust, there is no age limit for when we can create or fund the third party trust. People often ask how much they need to fund their third party special needs trust. And it's really impossible to give you a generic answer to that question, because it depends on how old your child is and what their needs are and what other resources there are that are going to contribute to your child's care. But as a general rule of thumb, if you've got a child who qualifies in theory for the comp waiver, meaning that they meet the definition of disability and they're qualified at least to be on the waiting list, which is what most people are in Georgia, the general rule of thumb is that we're going to need between $3 and $4 million to take care of that person over the course of their lifetime. If you want a more specific number than that kind of ballpark figure, one way to get it would be to do some life planning. So you would go to a financial planner that has special credentials and training, and they would sit down with you and figure out what resources do we have, where are they coming from, what projections do we have for benefits that we think the child will qualify for, and what do we need to supplement those benefits. And the Bobby Dodd Institute, if you're not familiar with them, I highly recommend that you look them up. They're a great resource. And they offer a service called futures planning, where they will do a highly detailed deep dive into the needs that your child has. And then that's a starting point for figuring out in your estate planning, where are we going to get these resources? So the best source of funds to fund a third-party special needs trust, of course, it's whatever you have. But many people will create their wills with a provision that says this percentage of my estate goes to not the child that has special needs, but to the trustee of the blah, blah, blah special needs trust. So estate planning is one way that people fund the third-party special needs trust. Life insurance used to be much more of a no-brainer when it came to funding third-party special needs trusts, because you can just, choose your dollar amount, pay your premiums, and know that you've got X amount of dollars headed straight for your child's trust when you're gone. Because of the Secure Act, which we'll talk about in a minute, life insurance has taken on a different role in special needs planning. One thing to think about is, if you have life insurance, is it term life or is it permanent life insurance? Term is not the best type of insurance to have when you have a need to take care of somebody that will never go away. Term life insurance is useful if you have a family full of neurotypical kids who are likely to go to school, get a job, get married, go out in the world, and have a life and be able to take care of themselves at some point. So we don't necessarily need to worry about what's going to happen if I die when my child is 45 years old. If we have a child who needs care and financial support forever, we don't want to have term insurance because it goes away, or it gets just phenomenally expensive as we get older. So it's a better plan to have a permanent life insurance policy if that's what you want to use to fund your special needs trust. And this is just a little incidental planning thing, but if you have a room and board agreement with your child, and there are good reasons to do that, like, for example, it allows them to collect their full $914 a month in SSI. Some people feel bad about charging their child rent, especially if it's coming from their SSI money. But if you view that money in your head as your child's money and you don't want to take it and use it for yourself, which you could do, one thing you could do with those room and board payments is you could use that money to pay premiums on a permanent life insurance policy. So that might be a way to fund this policy that will someday end up paying out into your child's trust. Inherited IRAs have become a super huge deal in the past few years, and that's because of the Secure Act. That became law in early 2020, so it hasn't been around that long. But what the Secure Act did is it dramatically changed the way that inherited IRAs get treated. Under the old rules, if you inherited an IRA, you could use your actuarial life expectancy to stretch that IRA and take out your required minimum distributions based on your life expectancy, according to the IRS tables. So under the Secure Act, unless you meet one of 5 exceptions, you now have 10 years to take the money out of an inherited IRA. And if it's a traditional IRA, that means you have 10 years to pay income tax on everything that's coming out of that IRA. So that's not as good a deal as the old deal where we could all stretch the IRA and take out a much smaller required minimum distribution and therefore pay income tax on a much smaller amount. So this is a big deal in special needs land because one of the exceptions to that 10-year rule under the Secure Act is if you are a disabled person or a trust for a disabled person and you inherit an IRA, you don't have to follow that 10-year rule. You can still stretch the IRA over your actuarial life expectancy. So because of that, a lot of my families are reevaluating what assets they're going to use to put into their special needs trust, because all of a sudden, the most tax efficient person to receive your IRA assets from a traditional IRA is your child with a disability. So some people are looking at their beneficiary designations and saying, we're going to put all of our traditional IRA money into the special needs trust because of that income tax advantage. And our typical kids will get the Roth IRA money. Or if the assets don't work out so that, we're distributing the amounts that we want to everybody, we reassess life insurance and say, this life insurance policy that I had always planned on leaving to the special needs trust, maybe I'll carve some of that out and leave some of the life insurance to my typical kids to make up for the fact that I'm putting my whole traditional IRA into the special needs trust. So this is obviously just general information, but if you're sitting down with a financial planner and trying to figure out how are we going to fund this trust, it's something to think about. So the Secure Act has really kind of been a game changer for special needs planning. Another wonderful source for funding the special needs trust, of course, is friends and family. Grandparents are often standing by, waiting until our special needs trust gets signed because they want to write a check to make a gift to the trust. And anybody can do that, assuming that you have an inter vivos trust. You don't have to wait till somebody dies to put assets into it. Other people can also name the trust as the beneficiary of life insurance or an IRA, or they can make a gift in their wills. If the trust is irrevocable, which typically it isn't unless we have a good reason, but this is a good reason. If we have a family that needs tax planning for estate tax purposes, that's not most people today because the exemptions are very, very high. They're around $12 million per person. But if the exemptions drop and more of us need to think about estate tax planning, one way to do estate tax planning with a special needs trust is make the trust irrevocable and then start making annual gifts to the trust to get that money out of your taxable estate. So most of us don't need to do that, but for those of us that do, you can do it. There are certain provisions that I love to include in a third-party special needs trust, and my favorite one is giving the trustee permission to own a home and the discretion to charge rent or not. And the reason that I love this provision so much, first and foremost, is because it allows us to do a perfectly legal form of money laundering. So it works like this. The trust owns a home. The trustee lets the child live there, but they charge rent. Well, remember, we can't put the child's money, which is first-party money, into a third-party trust. Only third-party money, meaning money that belongs to someone other than the child, can go into a third-party trust. So if we have a child who's on SSDI, which ultimately they probably will be later in their life, and they're getting a pretty significant amount of money, say they're getting $1,500 a month. We have to have something to do with that money to legitimately get it out of the child's bank account and keep that balance below $2,000. Because even though SSDI is not a means tested benefit, we always care about the means test. And that's because the older your child gets, the more likely it will be that they will qualify for one of those nice big Medicaid waivers. But if we let them have more than $2,000 in their bank account, they're not going to qualify because they won't pass the means test. So a way to keep the child's bank balance low and to get some of that money into the third-party trust is we charge the child rent. That's a perfectly legitimate thing to do, and it doesn't really cost the child anything because we're putting the rent money into this basket that's there to take care of the child. Another great thing about this provision is if the trust owns the home that the child lives in, the trustee is required, they have a fiduciary obligation to take care of that asset because it's a trust asset, which means the trustee's job is to know, do we have a leaky roof? Do we have bad wiring that needs to be fixed? Is there some condition in the house that's dangerous or that's uncomfortable for the child? It's the trustee's job to know about that stuff, and it's the trustee's job to use trust assets to take care of it. The trustee, being essentially the landlord, is also in the position to know, is there some random person sleeping in the bathtub because our sweet, trusting child met them at the bus stop and brought them home? The trustee has the ability as the landlord to say, no, sorry, you can't stay here. So it's really nice to have that ability to oversee the home and make sure that our beneficiary is living there safely and that people who aren't supposed to be there are not there. And of course, because this is a third-party trust that would own the home, that means that there's no estate recovery. So some people think, we'll just put this home in our child's name because during the child's lifetime, a home is an exempt resource. It's okay to own a home. You still qualify for SSI and Medicaid. But what they don't think about is at the child's death, that house is going to be part of the child's estate if it's in the child's name. So it's going to be subject to Medicaid payback. If instead we have the home in a third-party trust, there's no estate recovery. And the assets from the sale of that house go wherever it is that the parents want them to go. So another provision that I like is giving the trustee discretion to fund an ABLE account. And the reason that we might want to do that, even though ABLE accounts do have a Medicaid payback at the child's death, is that assets that come from any source other than SSI or an ABLE account are considered to be in-kind support and maintenance if we use them to pay for food and shelter. So if we have a situation where the child is living someplace where we're not in charge of what the rent is, maybe they live in a private facility, and we can't force the rent to be less than $914 a month, and I promise you it won't be. So that extra money has to come from somewhere. If the money comes from a trust, that's in-kind support and maintenance, and Social Security is going to reduce the child's SSI by a third. If the money comes from an ABLE account, that won't happen. So we can roll money out of the third-party trust into an ABLE account and then use the ABLE account to make up that deficit in the child's food and shelter costs without reducing the amount of SSI that they qualify for. And another provision that's really important, given what we know about the Secure Act, is there should be language in the trust that addresses how the trustee is going to own and administer any inherited IRAs. And that language is really technical and would take a long time to explain, but it's important that it be addressed in the third-party trust if we're going to leave an IRA to that trust. So one alternative, if you don't have the resources to pay an attorney to create a private trust for you, which is what I do, is to consider using a pooled trust. And a pooled trust works kind of like a mutual fund. So it's got one agreement that everybody signs, and then you put your money, whatever assets you have in the trust, into this pooled trust, and one trustee manages all the assets in that pool. So it's millions and millions of dollars, all contributed by different families. Because the trustee is managing all of those assets as one big pot of money, then they charge a fee that's allocated out over all of the members of the pool, and you get economies of scale. So it's not as expensive to have a professional trustee managing the pooled trust and charging you a fee every year as it would be to have a bank being a corporate trustee over your private trust. A pooled trust can be either a first-party trust or a third-party trust. It's a little bit hard to find a first-party pooled trust, but they're out there. And as I've already mentioned, these differ from private trusts in that you sign a trust agreement and you don't really get a vote as to what the terms are in that trust. You do get to name your successor beneficiary if you're talking about a third-party pooled trust. But other than that, the terms of the trust have already been decided, and it's just kind of sign here. The advantage of using this type of trust is it's less expensive to join the pool than it is to pay an attorney to create a private trust. And in fact, you don't need an attorney. You just find the pooled trust of your choice and you sign on the dotted line and you're a member of the pool. And the last thing that I wanted to talk about is the differences between special needs trusts and ABLE accounts. So ABLE accounts are not special needs trusts. They are not the equivalent of a special needs trust. They are accounts that exist under state law. Well, they were created by federal law, but the states now have been allowed to create them. And they're similar to the 529 college savings accounts that you're possibly more familiar with. When you put assets into a special needs trust, there's no limit to how many assets you can put in. And no matter how much money you have in a special needs trust, all of those assets are exempt. With an ABLE account, the assets are considered to be an exempt resource up to $100,000. So once you get assets above $100,000 in an ABLE account, they start to count against you for Social Security purposes. If you did fund your ABLE account above $100,000, once you got more than $2,000, you would fail the means test. Once you got to 102,000, you would fail the means test. So in a special needs trust, you can have as many special needs trusts as you want. You can have a first party trust, you can have a third party trust. Some people have multiple third party trusts. An ABLE account only allows you to have one per owner. The special needs trust can receive assets of any value and assets of any type. You can put a home into a special needs trust. You can put shares of stock into a special needs trust. You can put gold bars into a special needs trust. You can put anything into a special needs trust. But an ABLE account can only receive cash. There is no limit on what you can put into a special needs trust in any given year, but an ABLE account has a limit. You can only contribute up to $17,000 a year, and that number is going to change as the exemption from gift tax amount changes, but that's what it is this year, $17,000. And if your child has earnings from a job and they don't have a 401k plan available to them in that job, then in addition to the $17,000, you can also put earnings, put an amount that's equal to whatever your child has earned that year up to the poverty level. So if you're using a third-party special needs trust, there is no estate recovery by Medicaid, but assets in an ABLE account are subject to Medicaid estate recovery. So at your child's death, any assets that they have in the ABLE account will be subject to Medicaid payback. So that's all I have. Thank you all for your patience and for listening. If you want to see additional video workshops that I've done about various things that have to do with disability planning and guardianship, there is a link here for a YouTube channel where you can watch those video workshops. So that's all I have, and thank you for listening.